Okay, good evening. This is Delsteady Merced. Today is Tuesday, March 20th, 2018. The time now is 6 p.m. This webinar is being recorded. I must review a few important items before we get started. It's nothing new, nothing that you have not heard before, but I want to make sure that you do pay attention to it. First, an affirmation form was included in the email I sent you with the training outline. At various times throughout the webinar, there will be various codes displayed on the screen. These codes can be numbers, a combination of words, or both. You must write down the codes on the affirmation form. The codes will not be read out loud. Again, the codes will not be read out loud, so make sure that you are looking at the screen and writing these down as they come onto the screen. And I will tell you when they're coming onto the screen. The course code is now displayed. Mark, can you please forward to the second slide?
Yes. Okay.
Okay, the course code is now being displayed on your screen. Please write the course code number on the affirmation form. Submission of the affirmation form with the correct codes is required by the New York CLE Board and by NYSED for continued certification as a hearing officer. Please keep in mind that only hearing officers who participate in the entire webinar session would meet the training requirement and are eligible for CLE units. CLE credit will not be awarded, and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you viewed the live program for the full 2 hours. Partial participation will not be accepted. GoToWebinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, March 30th, 2018. Again, the date is Friday, March 30th, 2018, a week from this Friday. That date is also included in your affirmation form. Affirmation forms received after this date will not be considered for CLE credit, and NYSED will be informed that you have not met the training requirement. Second, all participants will be muted throughout the duration of the webinar. It's our intent today to allow you to ask as many questions and to receive as many comments as time allows. Should a question or comment come to mind during the presentation, we ask that you share either the question or the comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there is a question dialog box with the wording, quote, type questions here. Just type the questions, I will receive them. When time permits, I will ask the question of Mark or whomever, or read your comment out loud. We will pause to take questions or comments throughout the 2 hours, again, as time permits. This evening, we should be joined by your fellow hearing officer, Michael Lazan. We had 2 hearing officers lined up, but one was not able to join us. So Michael, thank you for assisting this evening. We also have Lynn Beekman as a panelist, and he will too be participating this evening. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to submit feedback through GoToWebinar. Please take a minute or so after the program to fill in the feedback form. One last word. A number of you with AOL accounts are participating in this webinar this evening. By now, you should have received an email from NYSED indicating that the AOL server is blocking emails from the listserv. Though you're not required to change your AOL account, I would suggest you consider providing to NYSED an alternative email account for use with the listserv. This will help to ensure that you receive important information from NYSED and us here, the training entity. With that, let's begin. Mark, I turn it over to you.
Well, great. Thanks, Dennis, and glad to be speaking with you all. It's an honor to have a chance to talk with you again. What I wanted to begin with is just to say a word or two about what we're trying to cover this evening. The topic, generally speaking, is eligibility under IDEA, and that obviously includes a number of different things, all of which are laid out in our topics for discussion. The one part of it that I mentioned in the outline and wanted to stress a little bit before we get further into the discussion tonight is that although I do intend to cover child find, which is a very important topic related to eligibility, the other important topic related to eligibility really is evaluation and how that ought to play out. But in the effort of trying to put together the materials for tonight, I found that topic was so large that I couldn't do justice to it within the context of what it is we're trying to accomplish this evening. So that will have to wait for another webinar or another discussion at some point. So instead, what I hope to cover are things like child find, the definitions, the idea of adverse effect on educational performance, the idea of need for special education, a little bit about Section 504 and how eligibility under that may or may not relate to eligibility under IDEA. And then finally, a little bit on statute of limitations. Not that there is much in the way of materials there, but I think that that might often have an impact on how decisions are made that are going to be in front of you all to try to resolve. So the beginning of that, of course, really is a little bit off the topic of those 6 specific things, but instead it's just the basics of what is a child with disability such that the kid would be entitled to services under IDEA. And I guess at the same time, that such that the district would be able to claim state and federal reimbursement for serving the child as a child with a disability under special education. This is probably familiar to most everyone, that the way that the drafters of the act, and this has been true since the very beginning of federal special education law, define a child with a disability is that you've got all of these various specific conditions, disabling conditions, intellectual disabilities, hearing impairments, speech language, visual, emotional disturbance, orthopedic, autism, traumatic brain injury, health impairments, SLD, and by reason thereof, the child needs special education and related services. So it really is kind of a 2-part definition that includes both this almost medical sounding type of criteria and then the need clause. Obviously, and I mentioned this in the outline, there is a further provision that talks about kids who are experiencing developmental delays, who are basically younger kids, and that effectively operates as another one of these disability categories. But the child isn't eligible under that either unless the child, by reason thereof, needs special education and related services. If we move on to the next slide, I put the New York definition into the materials as well. I don't think that I was able to detect anything indicating that the New York definition really changes what is in the federal definition. And in fact, of course, you'd have a bit of a federal supremacy problem if that were the case. But it's worth noting that you've got language here that does talk about the idea that you do need the disability as the basis for special education, and such things as lack of instruction in reading or math will not be grounds on which the child would be found disabled, which of course is true under the federal regulations as well, but should be, I guess, made a note of at the same time. I did mention in the outline and just did want to at least not miss the topic that age is, of course, also one of the criteria for eligibility under IDEA and under corresponding state law. The basic idea was that Congress did not want to upset those states that had somewhat more age restrictiveness than the drafters of what became IDEA thought of as ideal. And so it was made permissible that the child wouldn't be eligible even up to age 5 or after age 18 if that were a generally applicable criterion within the state. And it has led to a bunch of litigation. Hawaii has had a lot of disputes over whether, in fact, kids without disabilities are made eligible beyond age 20, I believe. Indiana had litigation as well because in 1986, greater incentives were created for school districts and states to serve younger kids. That issue appears to have kind of fallen out of the case law, but you still do see some cases related to age dealing with older age kids. Not in New York, however, as far as I could tell. Back to you, Dave Stady. Did you want to? Dave Stady.
I'm just unmuting myself. I'm dealing with
Oh, okay.
some issues with the with some hearing officers. But yeah, code number 2 is now on the screen. Code number 2 is now on their screen. Please write code number 2 down on the affirmation form. Mark, let me just look to see if there are any questions. I don't have any questions unless Michael or Lynn have any early comments. I'll leave the code up for just a minute or so. Michael, just check in to make sure. I see that you're on. Just unmute yourself and just tell me that you're on and you're able to participate.
I'm on and I'm able to participate.
Nice to hear your voice, Michael, as always. All right. And I presume by that you don't have any early comments at this point.
Not yet.
Okay. All right.
Mark?
Yes, Lynn.
I know I knew an idea that there were on like SLD. There's a clause that talks about it can't be as a result of environmental, cultural, or economic disadvantage, and I see that also slightly different in the New York definition. But coming from Michigan and with the Flint lead poisoning, I've never quite figured out how that would come out. I mean, clearly, I think that would fall with an environmental factor with those kids being disabled as a result of the lead poisoning. But that language has always troubled me. I couldn't. Have you ever seen anything ruling on that?
You know, that's actually triggered more commentary in the secondary sources than it has among courts, as far as I can tell. The basic idea, I think, was what in the legislative history of the '04 Act, some sources referred to as instructional casualties. The idea that there are some kids who just haven't been given adequate instruction, but don't have disabilities, but kind of look as though they have disabilities because they never got exposed to good teaching. And I think that's really what that's trying to get at. It's not trying to get at the idea that because you experienced an environmental disaster, you now have got some kind of injury that actually fits within one of the various 10 or 11 categories. The folks may or may not have an interest in the fact that there is now a class action going on in Michigan over whether kids who had been exposed to lead as a result of the Flint situation should be reviewed and considered for eligibility under IDEA. That survived a motion to dismiss for failure to exhaust, and the Sixth Circuit just turned down an appeal on that.
I do have a comment here, but you may be getting to this later. So if you want to defer, that's fine. What does other health impaired refer to? Is ADHD sufficient for other health impaired when there is no other classification?
Yeah, and that's a question I'll try to answer now, although I'm not sure I've got a fully adequate answer. From what I could tell, back in the earlier days, OHI was most often used either for kids who had chronic diseases of one kind or another, or quite often for autism. When autism was added as a category, it was no longer quite the issue, but OHI then wound up being used for kids with ADHD or other attention deficit issues, although I think an argument can be made that if the ADHD rises to a certain level, it might fit into the category of learning disability as well. The Congress did reject the idea of actually having a separate category for ADHD and ADD, but as far as I could tell from the legislative history on that, it was that they simply didn't want to add categories endlessly, rather than that they wanted to express an idea that it wasn't covered.
I have another comment here. My impression is that kids who bear victims of lead poisoning are routinely covered in New York State districts.
Oh, well, that's helpful. Yeah, it's a good observation.
Can you address how mental health disabilities comes under health? And do all students with mental health issues have to be classified as ED?
This one we will actually pick up a little later, but I do want to emphasize that the criteria for example, emotional disturbance are fairly narrowly maybe is too strong a word, but at least fairly specifically laid out. And there's at least some support for the proposition that simply because the kid has something that fits within a mental illness category, that does not automatically qualify the kid under IDEA.
Okay.
Okay, let's move on to our next topic, which is child find. And we've got really a variety of things here. I don't think that that we need to go over the specific statutory or regulatory language. The only thing of interest on it that maybe isn't all that widely known is that it actually preceded the 1975 Act. There was an effort by mostly parents of kids with disabilities in the very late 60s, early 70s era, really to try to trigger support for something that would become IDEA. And part of what they did was they wanted to have identification to kind of see how big the need was and kind of trigger possibly demand for law. And so the child find requirement has actually been around since 1970. Of the cases that are interpreting it, there are quite a number that essentially say the school district didn't do enough and so failed to fulfill their child find obligations, and then a fair number that say, no, what the school district did was legally permissible, even though they did not initiate an evaluation of the kid. There wasn't a sufficient basis on which to make that evaluation. The Board of Education of Wappingers against MN is the first one that I mention in the outline. Let me give you a quick update on that. I was just checking Westlaw about 2 hours ago and discovered that yesterday, if the Westlaw docket is right, and they put disclaimers on it saying that it's not always right, but I've never found it to be wrong, the appeal was dismissed for the failure of the respondent to file a brief. Now, maybe they just blew the deadline and they'll be able to reinstate the appeal if they do come up with a brief. But it could be that this is one where it proper will be denominated as appeal dismissed. The basic idea in that case is you did have a kid who arguably had a psychiatric impairment. The kid was being thrown out of her boarding school because she was continually hurting herself and seemed to be expressing thoughts about suicide. And the parent wanted the school district to find the kid eligible and to establish a placement for the kid. The school district felt that they had a good reason to sort of hold off a little bit before undertaking a full-fledged evaluation. They wanted to see what the kid's situation was, but ultimately didn't really do anything until the parent explicitly requested a referral, and the court found that in that situation, given the kid's underlying problems, that was a child find violation. And yeah,
Mark, just as an aside, I did get an email earlier today that the case was settled and the appeal was withdrawn. And that's
okay,
why,
that's
yep, that's why you have that.
Great, okay. So everybody's on one page on that. The couple of other cases that struck me as being important and that had some local significance to them as well. The Dean against School District of Niagara Falls is an older case, but one that still might be of some interest. The basic idea there is simply, once again, that you don't have to wait for the parent to make a request for evaluation. And if you do wait and ignore signs that the kid is suspected of having a disability or basis for suspected of having a disability, that triggers a child find violation. And then there's this, again, somewhat older case, the Board of Ed of Syracuse from the SRO, once again reinforcing that basic idea. The point's been made more than once as we've been doing these webinars that the SRO decisions, although obviously they're predictive of what the SRO will do, are not precedent in quite the same sense that you think of judicial precedent as being precedent. Nevertheless, I think that the key point being expressed here is not surprising, the idea that you shouldn't wait for, if you're the district, for the parent to ask for an evaluation, but also simply the facts here are of interest. So you've got a kid who appears to have some emotional problems, but truancy seems to be the key thing that the district saw as the problem. And the district felt that, well, if the kid is simply truant, that's not a disability nor necessarily a sign of a disability. It might be a sign that the kid doesn't like school or that the kid is lazy or something else, but not necessarily a disability. What the SRO seemed to emphasize in this case, though, was that you did have disciplinary violations, you did have a neuropsych report that indicated an emotional problem, and the absenteeism continued even after the kid was in therapy. And that seemed, at least from my reading of the case, to be the key thing that pushed the SRO into making that decision. So a word as to how predictive that might be, who knows, but it could be that if you're looking at a situation where truancy continues after the existence of intervention and where you've got other indications, that I think would be likely to be viewed as support for a child find violation. At the same time, I did mention in the outline, and I think that it's worthwhile pointing out, that not every kind of possible indication of a problem is necessarily going to be the basis to suspect a disability such that you would have a child find violation for failing to initiate an evaluation. The WA case from 2016 in the Southern District is probably a good example of that. The kid does have migraine conditions, which probably could, if they rose to a sufficient level, qualify as other health impairment. So it's not surprising that that would be the case. But the key result of the migraine mostly was that the kid had to miss school frequently, but nevertheless seemed to be doing just fine in school and didn't have the same kinds of problems that many kids missing school would seem to have. As a result, the court felt that there really wasn't a violation of child find here, simply a kid who had absences because of a health condition, and that was nothing more than that to it. The Ari against Brewster case actually got some commentary, as far as I could tell, among lawyers, and that's the other case that I mentioned in this paragraph. That's the one with the kid who has Tourette's syndrome, a variety of other kinds of conditions. Once again, the kid seemed to be doing okay in school, at least with a variety of accommodations that the district felt could be achieved under a 504 plan and was administering under a 504 plan. The court was persuaded, I think, by the fact that the kid seemed to be meeting all of the state proficiency standards and seemed to be getting along just fine with about average performance in grade level. And so as a result, once again, felt that there was no ground on which to suspect the disability.
Mark, I had a
Yes.
question on that.
Yeah.
It almost seems like a court that's saying, well, Beekman is doing okay because he's having 504 accommodations. It reminds me of the looking at a 504 eligibility case and taking away the mitigating circumstances in order to really determine the kid's eligibility. Here it almost seems like it's applying that case. If Beekman's getting along okay with 504 accommodations, there's no reason to suspect he has a disability.
Right.
But what if you took away the 504 accommodations? Would there then be reason to believe he might have a idea disability?
Yeah, I mean, I think that that's a paradox, just the way that you've got the definitions set up. Obviously, when they were drafting the section, or when they were drafting IDEA, back in 1975, they did have uh, Section 504 and the beginning of the 504 regs. The kicker is that nobody had yet really worried much about the mitigating circumstances. Nobody really did, as far as I could tell, until around the 1990s when you had all of those cases under the ADA about mitigating circumstances and everything else, the United Airlines and all of that. The way, a way out of that, or a possible solution to whatever paradoxes or dilemmas might be, is what, and this is a little later in the outline, but not much, is the approach taken by that LJ against Pittsburgh case. Pittsburgh in the suburb of San Francisco, Pittsburgh, out of the Ninth Circuit. In that one, the court said, well, the kid's getting a bunch of interventions. On the other hand, the school district is saying that because of the interventions, the kid is not in need of special education. Looking, however, at the interventions, it seems that those interventions are not things that would be part of general education. So therefore, in our view, the kid, in fact, is doing adequately, but only because the kid is getting special education, but they're not calling it special education. So therefore, of course, the kid is eligible. And it seems not to be a particular problem to the court. And in fact, there's an earlier opinion that lists some interventions that in an amended opinion, the court deletes some of the interventions because apparently there was some problem with the record with respect to those interventions. It may be that as a result of cases like that, there might be some reexamination as to whether the existence or the provision of these various accommodations, if they're extensive enough, in fact, evidence eligibility under IDEA far from diminishing eligibility under IDEA.
If I could add to that, this is an issue that I've seen a number of different times, and as I recall it, there are cases out there that say that school districts can't pick and choose between statutes that they like. So I don't know who the judge was in that case, RE, but I'm not sure that that's necessarily the consensus view in the country, that the school district can just provide 504 and then completely eliminate any need to evaluate a student pursuant to the idea. I've struggled with that actually, and I think I've ruled both ways on those cases, but that's one of those issues that really do come up.
Right. I strongly agree with you that there really are splits on that topic. And I tried to actually cover that a little bit elsewhere in the outline as well. But the fact that you've had decisions that go both ways on that, that's true for a whole lot of other people in courts as well. You've got Pittsburgh on the one hand, or the LJ against Pittsburgh case. There's another quite prominent case from about 10 years ago called Hood that goes in the direction of RE. But that Mr. I case, which is also in the outline later on, goes directly opposite to Hood and says, yeah, the kid's getting the 504 accommodations, but the kid is still in need of special education. So I echo what you're saying. I reinforce it, but I'm not sure I've got a definite solution to whatever you might describe as the problem or the dilemma that it might present.
In those cases, it seems to me that as a hearing officer, you have to decide who's right. Decide if the school district is being reasonable and the parent isn't complaining about the 504 plan and the 504 plan is substantive. Or if the district is clearly just trying to make sure that they don't have to deal with hearings or something to that effect.
That's an interesting point. I agree.
And Michael, I take it your reference in the last point, deal with hearings, is it's been my experience that in mediations and as a hearing officer that oftentimes the parent wants idea because of the procedural protections and the IEP plan's detail as opposed to 504, which is obviously not as prescribed in terms of the plan, and the procedural protections are perceived to be far less.
Plus, there's not that many attorneys who know it, special ed attorneys who know anything about it. and how do you find a competent counsel? I would say that would probably be part of it as well.
Huh, interesting. And that there is an underlying paradox through much of the eligibility discussion, certainly in the eligibility case law, the fact that, well, if you do determine that the kid is eligible, you're entitled to the federal and state money. If the kid is only under 504, you're not for that kid. So you would think all of the incentives would actually be for the school district to identify, but that's not the case. And in fact, of course, you often have school districts spending a lot of money and a lot of effort to resist the identification. And it could be that that's for very strong, sound reasons, that they don't want to place stigma on a kid with an identification that they think is not proper, or that they, as a matter of conscience, just can't feel that the kid fits within the definition. But it also could be that there are concerns about triggering procedural protections or the like, and those would seem not to be legitimate bases on which to resist the eligibility.
And Mark, a lot of parents would say, you just meet my kid's needs. I just assume he or she was never labeled anything.
Oh, absolutely. I would feel the same way as a parent. Yeah.
And so some different non-legal factors obviously enter into this, but.
Yeah.
I have a comment from one of the hearing officers here. In ruling against a 504 plan once, I described it as a plan to make a plan. Of course, that was the flaw in that plan, nevertheless, somewhat generic about 504 plans.
Interesting. Yeah, often they are less specific. There is actually some case law, notably that S1 against Turlington case from way back in the 80s, suggesting that due process protections before expelling, MDR type protections do in fact apply to Section 504 kids. But as Michael was saying, that's much less well known, and it's much harder to find a lawyer who's up on that topic from the perspective of the parent. Let me mention a word or two about remedies, and I don't really have much specific here, but did want to mention a couple of things. The Compton case is one that does require an extensive kind of compensatory education remedy, and it's a rather disturbing case in and of itself because it deals with this kid who was socially promoted, as far as anyone can tell, all the way up through high school, even though she basically could neither read nor write from what the opinion seems to describe. And the court there allows this quite extensive remedy going back through the entirety of her academic career, and using that as the basis for compensatory ed. But I thought that I would throw the Boos against District of Columbia case in here as well. There's been, this could probably be a topic in and of itself, a lot of discussion about just what it is compensatory education ought to entail. And Boos stands for the proposition that whatever it is, it's more than whatever would be deemed to be appropriate under whatever standard Rowley, Andrew F. Would constitute appropriate education for the child given the child's current condition. So it's something extra, with the court in Booz essentially not saying what extra it is and instead remanding that down to the other decision makers to try to figure out. But it does stand for that proposition, and I think that proposition seems fairly persuasive, that it isn't just that you bring the kid to appropriate ed as of now, but instead the compensatory remedy really is, in some valid sense, compensatory beyond whatever is appropriate currently. Lynn, actually, when we were first discussing this topic of eligibility, raised as a question, well, is there something we can really talk about as whatever triggers the obligation to evaluate? And to some degree, of course, we've already talked about that a little bit. Is there a basis on which to suspect there is a disability? The criterion for whether the kid is entitled to an evaluation is, again, whether there is suspected disability. But there are a few cases that do actually go into what you might describe as kind of a triggering or a basis for seeing whether the child find obligation or obligation to evaluate begins. And so I thought I would bring those to folks' attention. They mostly, however, are cases that are out of New York, so they'd be only persuasive authority, but they might be persuasive. Most of them, or the ones at least that I thought that were worth your attention, are ones that are pretty recent, with one exception. So I would point to this SD against Portland case, although I think in the outline I actually omitted the V. But anyways, case out of Maine that talked about a regression in reading relative to the expectations for the kid's age. The CC Junior case, to me, is quite an interesting one. This is one where the mom had an affiliation, had worked with the school district at one point or another. She thinks the kid has a speech impairment. She calls up the speech therapist or speech pathologist for the district, who I guess she had known before from her previous work there, and plays a recording of the kid's speech. The school district doesn't act on it immediately, but the court ultimately determines that that playing of the kid's impaired speech to the pathologist over the telephone was enough to trigger the obligation to evaluate for speech language impairment, something that I hadn't seen in any other case before. It could be that that's just an odd, unusual situation that won't ever arise again, but it probably does show a court that is quite concerned that kids do get evaluated and that there is no excuse for not evaluating a kid. The Doe case, which is that one older case that I wanted to throw in, Doe against Metro Nashville from the Sixth Circuit, I thought was useful because it reinforces the idea that I think was present in the other cases we talked about, that simply because the parent is generally aware that there are special education services out there, that isn't something on which the district can rely in, again, expecting the parent to demand an evaluation if the kid is manifesting something that shows a reason to suspect a disability. The RTI is kind of the other issue to my mind that is like our Section 504 issue. So it's another basis on which a kid might be receiving some forms of interventions. And I guess, unlike Section 504, response to intervention was, at least at the time of the amendments in 04, viewed perhaps as a kind of another way in which to determine whether a kid has a learning disability, as opposed to the dominant approach of the era of looking at the kid's IQ tests and seeing if there are discrepancies among the subtests that would indicate a learning disability. So I put in the one case from the District of Connecticut that seemed to discuss that in a somewhat greater detail than seemed to be the case with a lot of other court decisions. There, the school board had said the kid was making progress under this response to intervention regime, was doing better than the kid had been doing before. The court said that that wasn't good enough, and that the child's performance still was below what would be expected of a child in the child's general age range, particularly given that there had been some months of RTI intervention. And so the court felt there was reason to suspect disability, and a more formal evaluation had to be given. So that doesn't answer the question, I think, that Lynn had originally proposed of, well, is there something specifically that triggers the obligation to evaluate? I guess you can answer that by saying if there is a basis on which to suspect a disability, but that verbal formula I don't think necessarily helps you all that much. What instead you've got are a variety of holdings with possibly analogous cases that or analogous facts that might be used to try to determine whether the obligation has been triggered.
Mark, let me ask this question. I mean, as I recall, OSEP has come down with a letter ruling of some type to the effect that merely because a child is involved in an RTI evaluation or process does not excuse a district from honoring the request of the parent to evaluate the child under special ed.
Yeah, no, that is definitely the case. Yeah.
So, do I understand this? Do I understand this Greenwich case then to? I mean, does it really make any difference then if there's reasonable cause to suspect whether the kid is or is not involved in an RTI process?
Well, I guess a couple of things probably are relevant to that. First, as you mentioned, what seems to be coming down from that interpretation from the US DOE is the idea that you've still got to honor the parent's request. And either you have to say yes or you have to say no and give a reason, and then that's in itself appealable and can go through the due process procedure. I think, though, that is somewhat separate from the idea of whether the school district using RTI ought to initiate the evaluation even when the parent hasn't requested it, which seems to me to be the big topic in Greenwich or in other cases where, again, an RTI intervention might be undertaken, but where the kid hasn't been found eligible or even evaluated for eligibility in any other sense.
Mark, I have a question from one of the hearing officers. I recently had a case in which the parent claimed a violation of child fine based upon an alleged misclassification of the disability. There was no question that the student was identified, evaluated, and given an IEP. Does a misclassification case ever rise to a child fine case when the child has an IEP?
I will try to answer that question as directly as I can, but I still might leave our questionnaire unsatisfied. So there are a fair number of cases where courts say things like this actually was put into the law in 1997. The law requires evaluation in all areas of suspected disability. You didn't evaluate this kid in this area which you should have suspected was an area of disability. Therefore, your services were not adequate. Therefore, the parents win. And that often is said even though you might say in a general sense that the kid has been given beneficial education under a sort of Rowley standard. So there's that. On the other hand, you also have a fair number of cases that say things like you're simply debating whether the kid fits under eligibility category A, B, C, or D. You shouldn't care. As long as the kid is getting appropriate services, it doesn't matter what eligibility category the kid is in. And in fact, it really doesn't. And there's US DOE interpretations saying essentially that as long as the kid is reported to DOE under one of the various disability categories, there really isn't any requirement otherwise to make the kid fit into one thing or the other. The problem with that being, from what I can tell from talking with parents' lawyers, is that, well, that may be right, but in many places, so they say anyhow, um, there are either unwritten or sometimes even written rules that seem to restrict some kinds or levels of services based on what category the kid fits into, and sometimes how deeply the kid fits into the category. The kid meeting some criteria within a given category that are set up by the school district or by the state. So you do occasionally see parents, more often parents, but sometimes school districts, go to the wall on whether the kid fits within one category or another. And as far as I can tell, that's because of these practices as to which services the kid is going to wind up being. Although possibly that could also be that, there are some categories that probably have somewhat less stigma attached to them. Plainly, the LD category is usually thought of as being somewhat less stigmatic than intellectual disability or than emotional disturbance. So I hope that answers the question. If people are looking for cases on that, I actually do have a law review article called All Areas of Suspected Disability. If you Google my name and the phrase all areas of suspected disability, I think you can find a copy of that might very well be in the public domain. So take a look.
Mark, one hearing officer makes the point in response to what you just said that New York State approves non-public schools to serve kids by classification.
Oh.
So classification is crucial for the non-public school placements. So that's the comment on that.
Yeah, that's an interesting point. Yeah.
Yeah. So my question to you is, going back to the first question where the hearing officer has, at least in the due process complaint, an issue with respect to misclassification as a child find issue before her or him, and the parent insists this is what the issue is.
Mm-hmm.
And as you just answered, well, it goes beyond that. Doesn't it go to the appropriateness? And the parent may just be, or the attorney for the parent may just be identifying the incorrect issue. How do you address that?
So it's almost as though, do you have either an obligation or permission as a hearing officer to kind of rephrase the issue? Would that be a way of describing that, or are you thinking of something different?
I think that is the question that comes up. I think I'm alluding to that. And by the way, Mark, I could give you a pass. You have Lynn there. You have Michael, who both serve as hearing officers, and just because I think that's a real issue, which is the parent insists, and we train, and when we train, we say, hey, once you understand the issue, if the issue is clear, you don't go beyond that. You don't present the case, or you don't try to change the case to how you would have presented the case, what you think the theory of the case should be. So it's just, that's a tough question.
I don't know if Lynn or Michael want to weigh in on that. That would give me a moment to
I'll
think.
weigh in. I'll weigh in because it's happened on several occasions over the decades where a kid will be labeled X, and the parent says, I want the kid labeled Y, or they want the kid labeled both X and Y. And I always ask, why do you want the child labeled the second category or a different category? And it usually gets to the point you raised, Mark, with respect to some school districts, either formally or informally, for various reasons, think that a child has to be labeled a certain thing in order to get services in response to that label. And sometimes it's merely the perception of the parent and it isn't reality. But at least by asking the dumb question, why, you can kind of tease out what the real underlying issue may be.
Usually,
Go ahead, please.
Usually, it's the parent feels that there's a stigma to one of the classifications, and it can be devastating to have your child labeled a certain way, officially labeled a certain way. And even though it may not be that important in terms of the services, there's more to this than just the services for a lot of people.
Interesting. But I would also not lose sight of the idea that if the private schools are designated by category, then the category, of course, could be critical. So I wouldn't rule that out either. Well, I hope that gets me off the hook on opining on that topic. But
yes, you're off the hook, though. I don't
okay.
think neither Lynn or Michael tackled the actual question I asked, but that's okay. I'll give them a pass too.
Okay.
Let me ask this question. In my state and others, there are other benefits that by different laws that piggyback on the classification of the child.
Yeah.
And I don't know whether that's true in New York, but if it is, that's another reason why a parent might seek a particular category.
Huh. And that is, of course, another thing that you have to be worried about, or maybe not worried about, but at least maybe should be conscious of. Obviously, there are services that are available, at least as of the status quo, under such things as the the Developmental Disabilities Act, or what it currently is incarnated as. And there's also the Traumatic Brain Injury Program and a few other programs. We've got a specific program for mental illness here in Illinois, and it's not something I would fault a parent for, to try to make sure that diagnoses are more or less consistent, or possibly to try to use an IDEA evaluation or record for further support for any of these various state or federal programs that might provide additional services.
And with that, two comments came in. Unfortunately, I don't know what the acronyms stand for, so I'll read them comments. But you'll get the gist of it from the overall comment. Unfortunately, later in life, OPWDD may review school records, and LD does not cover it. I think classification is important to be accurate. The second comment is there are some DDSO services in New York that are tied to classification under autism.
Right.
And then again,
so that sounds like essentially rehabilitation type services, or occupational therapy type services, or occupational related services.
Yep. Several non-public schools accept only one category, example, autism. Also public school programs, example, and this is a New York City program, ASD NEST program. Office, I got the act, office with people with developmental disability, and both of them said the same. Yep.
Yeah.
Thank you. Thank you for filling that in for me.
Thank you, our commentators. It really does give a much better sense of what might actually be going on here. Oh gosh, so we're up to Steady.
All right, well, code number 3 is up on your screen. Code number 3 is up on your screen. Please write it down. Give me 1 second. I'm jotting down the time that it goes up. So please, code number 3. Let's leave it up for just
Sure.
10, 20 seconds there, and then we'll move on since I have no more comments or questions.
Great. Actually, we can leave it up for a moment. I can just do a little bit of a segue into our next topic. So almost in a response to what it is we've just been talking about, although it was planned out long ago, the next thing actually to talk about is a couple of specific disability categories and how they work in, although I didn't actually come across any recent New York cases on the specific topic of does the kid fit into category X or category Y, but I have tried to marshal some cases on the one hand, emotional disturbance, and on the other, specific learning disabilities, which really are the two areas that are most frequently contested with regard to whether the kid is eligible or not. So we will take up these specific disability categories for anybody who has an interest or a concern over that. Can we move on? Do you think, Dave Stady?
You can, yes, of course, you can.
Okay, good. So the two specific disability conditions that I did want to make sure that we talked about at some length were emotional disturbance and SLD. And so in the outline, I've actually got the entirety of the federal reg defining the emotional disturbance, and the New York provision is the same. The sites are on the PowerPoint. What the category here, the definition, really looks very much like a mental health diagnosis type definition. So it's a condition exhibiting one or more of the following characteristics over a long period of time and to a marked degree that adversely affects a child's educational performance. And so it's got inability to learn that can't be explained by intellectual, sensory, or health, inability to maintain satisfactory interpersonal relationships, inappropriate types of behavior or feelings under normal circumstances, general pervasive mood of unhappiness or depression, tendency to develop physical symptoms or fears associated with personal or school problems. So that in and of itself is a fairly anodyne, I guess almost might say, fairly basic kind of a definition, and sounds in its nature fairly mental health-ish or medical-ish. There then, however, is a double I provision. Emotional disturbance includes schizophrenia. The term does not apply to children who are socially maladjusted unless it is determined that they have an emotional disturbance under the previous definition. That social maladjusted thing has led to all sorts of controversies over the ages. And so I was actually writing a law review article about, oh gosh, almost 10 years ago now, on IDEA eligibility. And I dug into the legislative history of the original 1975 Act to try to figure out where that might have come from. And of course, it doesn't actually show up in the Act, it shows up in the regs, which is even somewhat harder these days to try to track because much of that material is not fully available online. However, from what I could tell, and I've unfortunately, there isn't a whole lot of other source material on this except what I was able to find in the regs drafting. The term socially maladjusted was put in there to describe kids who are juvenile delinquent. And the reasoning appeared from, again, my judgment to be that the drafters of the regs wanted to find a way in which to say that simply because the kid is a juvenile delinquent, that doesn't mean the kid is a kid with disability eligible under what was to become IDEA. One might disagree with my interpretation of the materials, but for what it's worth, that's yet another law review article. It's in the Buffalo Law Review. If you Google my name and the term, the IDEA eligibility mess, which is the title of the article, you'll come up with the sources that I was able to locate on that topic. That being said, in some ways, the socially maladjusted business may be a little bit of a red herring because although the definition says that the term doesn't apply to kids who are socially maladjusted, the unless clause says, unless it is determined that they have an emotional disturbance under C4(1) of the section. So really that then shouldn't be any different than if they didn't have the socially maladjusted term in there at all, because in any case, you're going to have to meet the sub 1 or sub I, A, B, C, D, E criteria anyhow. However, there are some cases that maybe, just maybe, create some difficulty in trying to work that out. The way that I set up the outline, I kind of put all of the cases in a row with those that wind up finding kids eligible first and those that don't find kids eligible second. And so as a result, I'll kind of take up the socially maladjusted where it comes in, but not specifically as the next thing that we talk about. The next thing that I did want to talk about was instead the couple of cases that struck me as perhaps the more significant of the Second Circuit and New York cases that do find kids eligible under the emotional disturbance category. So one of these is that Muller case from 20 years ago, where the kid has, once again, some difficulties with learning, And as far as you can tell, the basis for an emotional disturbance categorization really is simply depression, a pervasive mood of unhappiness or depression for a long time, and not much else. Really they're relying specifically on that. And the Second Circuit thought that, well, that's in the definition and it fits, so therefore the child should have been found eligible. There's a somewhat more recent case, that Ashkenazi case out of the Southern District of New York. This one actually does take up a little bit the socially maladjusted topic, but doesn't define it as I think might have been the intention of the drafters of the regs as juvenile delinquency, but instead just talks about social maladjustment as being maladjusted and being maladjusted in a social environment. But I think the court, and again, in my view at least, correctly says, yeah, but in any case, you've still got to look at what these definitional factors are and say that, well, once again, we've got a depressed kid. The depressed kid has a general pervasive mood of unhappiness or depression. That's under D of sub 1. So therefore, that's good enough because it also adversely affected the child's educational performance, which is the other part of that definition. So once again, the court ultimately finds that there is eligibility. Ditto with that New Paltz case that I've got in the outline. That's one where, and this kind of does raise the issue that Lynn had mentioned a little bit ago about the situation, this is before we actually began the seminar, about the situation that the kid is in socially that doesn't necessarily relate to school. So the kid was doing fine in school until the parents divorced, at which point the kid starts becoming a discipline problem, starts using drugs, has problems that do appear to be pretty closely tied to that one event. Once again, the court here seems to be emphasizing, however, that it really doesn't matter what the basis or the origins of the problem happen to be. Instead, it's whether the kid fits within the definition of displaying the inappropriate behavior or inability to build relationships or inability to learn that can't be explained otherwise, and that's the key thing. I've also included that.
Mark,
Yes.
isn't the key that those inappropriate behaviors are displayed in the school setting, not, I mean, I can recall some cases where the kid was an absolute disaster and a mess socially outside of school, but for some surprising reason, they never manifested themselves in the school setting.
Yeah. In my mind, that even though the A, B, C, D, and E factors, some of them mention school, some of them do not, but all of them still would require adversely affects the child's educational performance. So if it doesn't adversely affect the child's educational performance, then I don't think it's covered by the definition.
Yes.
The AA case is that one other case that I thought I would throw in, partly because it's just very recent, but also because it establishes, I guess as some of the other cases do, that simply because you've got good grades doesn't mean that the educational performance isn't adversely affected. So you kind of have to look to see whether that adverse effect is there. It also, of course, you're still going to need, if you're going to find the kid eligible, that the child is in need of special education. This is simply putting the kid into the category of emotional disturbance. You've still got the second half of the definition to meet, or of the eligibility criteria to meet. I did want to make sure that we mentioned cases that go in the other direction, because there are plenty of them, and they're rather noteworthy. Springer, in fact, is probably the case that is most commonly cited with regard to emotional disturbance. It's a Fourth Circuit case, again, now about 20 years old. The court goes into some length about the kid being socially maladjusted, and the definition of social maladjustment as juvenile delinquent is consistent with, but not precisely, what it is the judge is talking about. So the kid actually was involved in a bunch of criminal activity, some at school, some not at school. it didn't arise until the kid hit 8th grade and maybe hit puberty, I don't know. But in any event, he had all sorts of problems that did exist. The court said, well, the mere fact that the kid is socially maladjusted and all of that doesn't mean the kid is eligible, and even seems to think that the social maladjustment is kind of an exception or a carve out for emotional disturbance. But if you look at what the court actually did, it then, after saying that, did go through the specific criteria of the I provision, suggesting that, yeah, but you still got to see whether the unless clause applies. So unless it is determined that they have emotional disturbance under paragraph C4, whatever. And they do go through quite rigorously the various criteria and say that, well, no, there wasn't anything that we think fits into the criteria of the inability to learn that can't be explained, or inability to maintain interpersonal relationships, or any of the other criteria. There are a couple of cases that are relatively recent, medium recent, 2011, that come out of New York that I thought were worth knowing about as well. The WG and the PC case that talks specifically about drug use and say that the kid's problem stemmed from that. The kid, they say, is not eligible under emotional disturbance. So in terms of actual fact patterns, those might be of significance if you're trying to apply the provision here. They don't, however, to my mind, do anything to undermine the requirement that the criteria in the federal regs definition do have to be taken seriously and applied. One thing, though, and again, Lynn had mentioned this some time ago, was the relationship between things that show up in the DSM, the Diagnostic and Statistical Manual, as definitions of mental impairments, and eligibility under IDEA. And there really are maybe a couple of things that could be relevant to that. I couldn't find cases that seem to be of recency or within the jurisdiction here that seem to address that topic in a very, very direct way. But the RB case, which got a lot of notoriety again about 10 years ago, from, I think it was actually a California case originally from the Ninth Circuit, involving a kid who actually had some congenital problems related to exposure to drugs during pregnancy of the mom. That kid was not eligible, largely because although the kid did pretty much have diagnoses that even put the kid into the C or the 4C1 or C41 definitional things that are part of the definition of emotional disturbance, the court really couldn't find an adverse effect on educational performance. So at the least, if you've got a DSM criteria type diagnosis, but you still don't have an adverse effect on educational performance, no, the kid is not eligible under the ED category. There also is this letter to Co that Lynn had called to my attention that probably is worth noting, that once again says DSM, it was actually DSM-4 way back then, that isn't synonymous with the criteria for determining whether the kid is a kid with a disability, and so you can't simply look at that as controlling.
Mark, if I might just add a practical perspective here, as a hearing officer, I could not count the number of times that I have had a clinical psychologist or a psychiatrist come into the hearing and start going through all of the DSM-4 or 5 conditions that this child was diagnosed as having, which of course for us has limited relevance. And so on those occasions, I would try to diplomatically ask the expert if he or she had seen rule, whatever it was, that set forth the characteristics for usually ED.
Mhm.
And they sometimes would say no, and then I would show them a copy and give them 15 minutes if they needed it to look it over, because I would tell them that's what I have to use as my standard in large part to determine whether this child meets the characteristics of that category.
Hmm.
And then sometimes they would be able to just do it and tell me why, but other times they really struggled. But I find otherwise I would waste sometimes quite a lengthy period of time with them explaining their diagnoses and all of these clinical terms, which didn't really help us get to the bottom line in terms of, as you've discussed, does the child meet the characteristics in the definition?
Hmm.
So
Interesting.
I just offer that as a suggestion, and probably some of those who are participating in this have saying, oh yeah, been there, had to do that.
And I guess from the perspective of the whoever the witness is, I mean, they're more comfortable with that kind of terminology, and they're much less comfortable with whatever it is the drafters of the federal regs decided to put in. So I can see why they do what they do, but as you say, that's your job as a hearing officer is to apply the law, and so that's going to be the key thing that the hearing officer needs to focus on.
And the worst thing is if you don't do it and you get back and you got to decide, then you don't have a very good record to make the decision on.
Yeah, that's a valid point. Really, it is a key thing in making sure that the record fits the legal standard. Yeah. Although obviously that's a point that should be brought home to people who are lawyers as well in trying to present these cases. Let me mention a word or two about specific learning disability. This has generated a lot of discussion, was a major topic during the last revision of the statute in '04. There are any number of problems with the application of specific learning disability as a definition, including some states in which it appeared that the incidence of SLD was about 3 times that which it was in other states. And really some questions about just how it is you determine whether there is a specific learning disability, whether IQ tests can be relied on, cannot be relied on. Some of the discussion on that seems to have fallen out of the literature and the debates since then, and I'm not sure precisely why. It is true that you still do have cases trying to figure out whether kids are eligible under this category. Some of the more interesting ones, though, again, to my mind, deal with things like whether the kid's specific obstacle to learning is something that fits within the definition or not, or whether the kid should have been evaluated with regard to a specific suspected learning disability. And so, although I couldn't find much of anything that I thought was of huge importance or significance or even of, frankly, of interest, in recent New York court case law anyway, I did want to flag this one First Circuit case that talks about a reading fluency deficit and the need to both evaluate and to address reading fluency, even though the kid seemed to be getting good grades otherwise and didn't seem to have reading problems otherwise, except for this reading fluency problem, which had to do with this ability to kind of connect things and to be able to read with some level of speed and coherence, as opposed to the topic of simply being able to figure out what symbols on the page of paper or computer meant, or what even the general comprehension of text is able to be accomplished by the kid. So that's the Doe against Cape Elizabeth School District case out of the First Circuit from a couple of years ago. So I'd recommend maybe looking at that if there is a case that deals with a challenge to whether a given kid's condition does fit within what a specific learning disability definition is. But again, I couldn't find a whole lot else that seemed to be recent and relevant on that topic that I thought was of great interest. The next thing that I did want to mention, as we mentioned with regard to ED, I think it's implied with regard to specific learning disability, and it certainly is true with regard to the other disability categories, all of which are defined in 300.8 of the federal regs. There is this requirement of adverse effect on educational performance, and that has generated a fair amount of case law in New York, to the point where I've heard some commentators say that New York is kind of exceptionally demanding, in the sense that to find eligibility, you really have to have an adverse effect on educational performance, defined in a somewhat narrow way of educational performance, meaning success in terms of grades or success at school generally. And there are some cases that maybe do support that way of looking at what the New York case law looks like, although there are plenty of other cases out of New York that I think go a little bit in the other direction, and also would seem to suggest that you could have an adverse effect on educational performance even though the kid is getting adequate grades. So for what it's worth, I pretty much just accumulated the cases going in both directions, and certainly factual analogies could be drawn to almost any of them, given the facts that a hearing officer might confront in a specific case. The cases that again are relatively but not hugely recent, Mouse from 2010, kid does have anxiety disorder, a certain amount of, or certainly has what now we would call being on the autism spectrum, some cognitive deficits, but an IQ that falls within the more or less average range. Yeah, in fact, I would say within the average range. And seems in general to be doing okay in school. Court says not eligible, basically, because there isn't an adverse effect on educational performance. As they say, proof of an adverse impact on academic performance. And here they kind of translate educational performance to academic performance, which you may or may not agree with, is a prerequisite for eligibility for special ed services under IDA and New York. And that kind of then kicked back as well to another case called AJ, which doesn't look a whole lot different, except to the extent that the kid probably would have tested higher on a general intelligence category. The kid was an Asperger's syndrome kid in terms of diagnosis, but once again seemed to be doing okay in school, and the court again reads the educational performance essentially as academic performance rather than anything else. There are a couple of cases that also you will often find cited, even though they aren't New York specific. One of them is Second Circuit, but is a little bit, I don't know what the right adjective is here really, unique, maybe particularized, I don't know, but you do see it cited rather often. It's JD against Paulett, Second Circuit from back around 2000. The kid does have really a variety of problems academically because of an emotional condition, but didn't seem to be doing that badly in school. And in particular really wasn't below grade level performance in any of the kids' subjects. The court, in a somewhat unusual move, says, well, really what we need to do is look at what the state defines as educational performance. And Vermont, in its wisdom, describes educational performance to be an adverse effect as being significantly below age or grade norms in one or more basic skill areas, including oral expression, listening comprehension, written expression, basic reading, math, and the like. And since the kid was doing okay academically, the court says, no, that doesn't qualify. That's actually somewhat in direct contrast to the Mr. I case, which we mentioned, I think, a little bit ago, and I'll mention in the next slide, where a court confronting a kid who's basically an Asperger's kid, doing quite well in school, but with any number of other problems, says, well, yeah, but in Maine, our state definition of what education is really broad and includes social adjustment and all sorts of other things that the Vermont definition doesn't seem to include. So therefore, the kid is eligible. I'm not sure either of those is entirely right. This, again, is maybe more my opinion than anything else, but it does strike me as being a little odd that what should be, I think, a federal program where a kid who's eligible in one state, I would think, would be eligible in another state, would have the determination of eligibility depend upon whether the kid is closer to Vermont or closer to Maine, even though they've only got New Hampshire sitting out there between the two of them. So in any event, you do have that as a relevant case, perhaps, with regard to adverse effect. A couple of other cases that also go into adverse effect. We've got a Seventh Circuit case on that, Marshall Joint School District against CD, once again emphasizing that the kid is doing well in the classes. And although the kid there actually had, although the kid had ADHD, was basically an orthopedic type impairment that appeared to be the issue with regard to the kid's needs. That EM against Pájaro, if I'm getting the pronunciation correctly, case that I also mentioned here is a Ninth Circuit case that got a lot of commentary a couple of years ago when it came out, more than a couple, I guess now, it's 2014. That one has a couple of aspects to it. The one that I want to emphasize is the one on adverse effect. They don't find enough of an adverse effect. And they do say that there are things like failure to complete homework and other things that really are the source of the problem rather than the problems with the ADHD and other characteristics that the kid had. Obviously, you could argue that some of the problems that the kid might have with turning in work might be related to the disability, but the court was not persuaded on that topic. The other aspect of EM, though, that I don't mention in the outline, but maybe you'd want to be aware of, the kid might or might not have qualified under learning disability depending upon which tests the school district used. And the court there was of the view that as long as the district chose reasonably among the tests, it really could kind of pick and choose among the tests. And there were some commentators who felt that that was incorrect and that it really is an issue of fact rather than an issue of discretion for the school district as to whether the kid has a disability under the learning disability category or not. I did want to mention, and I guess this is to kind of rebut the idea that every New York case has a more limited idea of what educational performance is. The Corchado case, which is again, a fairly frequently cited one in New York from 2000, where the kids, as they say, turned in an educational performance in the sense of grades and the like that was within an average range, but did have a serious seizure disorder. And so as a result, missed a lot of school, probably could have been doing a whole lot better in school with interventions if the kid had been found eligible. And the court there says, well, that's enough of an effect on educational performance. And so we think that the child should have been eligible. And the thing that I noted in the outline and maybe is worth paying attention to, the court talked very much about the idea that it's an individualized determination and said, yeah, but this affects this child's educational performance. It's not educational performance in general. So if you're persuaded by that view, I think Corchado provides support for that view. I then mentioned Mr. I as well, and we've already talked about that, so I don't want to belabor the point with respect to it. It again, in some ways, like JD, does look to the state definition of what's education and what's educational performance. And I'm not sure that's right, but it comes to a different conclusion from what's in JD. So it could be that both of them are quite correct on their respective applications of state law, or maybe both of them are quite wrong. I don't know. I'll kind of leave that for you all to either agree with or disagree with.
Mark,
Yes.
do you know if any court opinion has ever, in determining the breadth of the term educational performance, taken a look at the structure of IDEA, its history, the fact that the evaluations have to be comprehensive, far transcending academic performance, that the IEP really gets into functional behavior and performance as well, and that the last part of a kid's school career with transition gets into things far beyond academics? Has any court ever approached it that way, saying, giving us such a narrow reading of educational performance in the IDEA context is just contrary to the whole scheme?
Yeah, that's real interesting. Of course, as a person who teaches in a law school, I would never say there is no anything, but it's the idea that it should be taken in context, and that what, after all, we're trying to do is administer a program of education for kids with disabilities, I think has a lot of persuasive force to it. You don't want to read any specific provision of the law in such a way that it defeats the underlying purpose of the statute as a whole. And as you say, the law here does entail a whole lot of things that don't seem to fit within what I guess those of us brought up in the 50s and 60s might think of as a narrow definition of schooling or of education. So I think that does support a broad view of what educational performance is, and that, such things as whether the kid comes out of school with an adequate level of socialization, might be an important part of that.
Well, I've never seen one, and I just wondered if you were aware of one, because to me, that's a key in terms of trying to figure out what the meaning of a particular term is. You just can't read it, as I think some courts have done, in isolation almost, or in terms of a judge's own experience where he or she, Marby was in general ed and that was it.
Mm-hmm. That Mr. I case, though I think to be fair to the judges there, I think is at least edging towards that approach. So that would be one I would recommend with regard to that topic.
Okay, thanks.
I guess the next thing that we probably, before I guess we get into the next topic, I did just want to mention a word about this AA case. This is once again a case where it's not New York, but it's a DC case. But the kid is, again, getting good grades, but has huge anxiety issues and just can't adapt to ordinary classroom instruction. And once again, the court finds the kid eligible despite the good grades. As you could suggest, we work our way through the various definitions of the disabling conditions and work our way through the adverse effect, which is the component of all of those various subcategories, but still then do have to take up the topic of whether the kid, by reason thereof, needs special education. It's true, I think, that this topic does to some extent overlap with the adverse effect on educational performance, because if there isn't an adverse effect on educational performance, it's going to be hard to say that the kid is in need of special education. But you might not ever get to whether the kid is in need of special education if you already determine that there's no adverse effect on educational performance. I don't know whether that comes across, but what I'm trying to get to is the idea that although we're talking about some of these cases in terms of whether the child's in need of special education and that is what the statute requires, it could be that if you as a hearing officer are looking for cases that would be relevant to the topic of adverse effect on educational performance as part of the definition of the disability category, that you still might want to look at some of these cases on need to see whether they might be relevant to what it is you're working on. That being said, I did find a couple of relatively recent New York cases that I thought would be of significance on this topic of whether the kid is in need of special education. So one of them is MM and the other is AW. MM is, again, a kid's getting good grades, but has all sorts of problems with depression, anxiety, and all that sort of stuff. The court latches onto the fact that the child was frequently absent from school. Now, interestingly, of course, as we discovered in some of the other cases, courts view absenteeism from school as not being a particularly big issue or being an indication that it's something other than an emotional disturbance that's the problem. But the court here was persuaded that there's an adverse effect on educational performance, even though the kid being absent from school still seems to be getting passing grades. And as a result of that, still is in need of special education, even though with the missing of school is nevertheless getting passing grades. Once again, I suppose what it really means is you have to look at the kid individually to determine whether that kid is in need of special education to determine whether the standards of the law are met. AW is a little different. It's not the emotional disturbance situation. It's instead sort of a classic dyslexia learning disability and ADHD. School district says, yeah, it's a kid with ADHD, but the fact is that he seems to be doing okay in school. He's, performing okay on all these achievement tests that we give him. But the court latches onto the fact, once again, I guess, that the kid could be doing better. That the kid does have problems with attention and with really just decoding of texts that hinders the kid in learning what could be learned with greater interventions, or I guess they're assuming that would be the case, and so does find the child in need of special education and says that the definition is met here without that, without anything more being needed to be demonstrated. Yankton against Schramm is a non-New York case, and I thought that I would throw it in, even though it's fairly old, partly because it is cited fairly frequently. It's a little different, again, from all of the other cases, because it's a case dealing with a kid who's got an orthopedic impairment that, among other things, prevents the kid from writing well. And so the court thought that was enough of something to trigger both an adverse effect on educational performance and a need for special education, even though, once again, the kid seemed to be doing okay on conventional measures of educational achievement, at least with Section 504 accommodations. And that, to my mind, then kind of fits in well with a lot of the other cases dealing with Section 504 type accommodations. The memorandum to state directors that I've got mentioned there as well is it's the bottom of page 9 of the outline materials. OSEP has said repeatedly that you can't just use cutoff scores or the fact that the kid is passing from grade to grade, or even that the kid has high level of cognition as being a sole basis on which to disqualify the kid from eligibility for special ed. So I think that kind of reinforces what you see in MM or AW or Yankton. And the LJ case, which again we'll discuss a little bit greater length later on, is emphasizing that as well. That being said, however, and I don't want to lose sight of this, there still are a fair number of cases, some of them quite recent, some of them perhaps that have persuasive impact to them, indicating that no, the kid is not eligible for special ed because the kid is not in need of special education services, even though school district concedes that the kid has one of the various disability categories that are laid out in the statute and the regulations. Of those, probably the two most prominent are Alvin and Hood. Alvin out of the Fifth Circuit and Hood out of the Ninth Circuit. Basically, one is an ADHD case. The other is kind of a multiple disabilities case. And they both emphasize the idea that the kid is getting good enough grades or passing achievement tests. Alvin did also involve juvenile delinquency. Hood is a little different. The kid is getting various accommodations under 504, and the school district and the court agrees with this, say that that's enough and that the child is, for reason thereof, not in need of special education. There are a couple of more recent cases that probably should also be paid attention to. There's a somewhat elaborate Devon litigation resulting now in a cert petition where it's again a little different from some of the other cases, not so much because the facts are that strange or anything else along those lines, but the Fifth Circuit, and you'll see this show up in, as I suggested, that EM against Pajaro case out of the Ninth Circuit puts a lot of emphasis on deference to the school district in its determination as to whether the kid is eligible. And again, I'm just sort of presenting as an open issue whether that makes sense or whether the eligibility determination really is just it is or it isn't, and it's not really a matter of discretion for the district one way or the other, the way that, for example, you might defer to the school district on methodology or other determinations under an Andrew question about appropriate education. Nevertheless, Hood does stand for the proposition that there is some level of deference to the school district. As I suggested, that Ninth Circuit case that is more recent, the EM against Pajaro case, again suggesting a kind of deference to the school district on this issue of either on the one hand eligibility under the disability categories or on the other the need for special education. I also wanted to mention Aransas, or MP against Aransas. This is a case out of Texas I've seen cited now a couple of times where it emphasizes the by reason whereof rather than the need for. I think effectively it's still saying that there is no need for, but it is at least somewhat unique in placing its emphasis on the whether there's an adequate causal connection, and so might be worth examination based on that, even though, again, it's out of district and may or may not be applicable to a given case. You could probably have anticipated what would be coming up next. You know, if the question is, there's a requirement that you have to have an adverse effect on educational performance, or that there's a need for special education, and of course then both of those are required, you really then do have to ask, well, what does education mean? And that's in a way what the Mr. I and that JD against Powlett case were trying to wrestle with, and decided that, gosh, we don't know, let's look at state law to try to figure that out. The LJ case, though, is probably the most significant recent case on that topic. So LJ involves this kid who's a behavior problem, I guess, to put it mildly. So the kid appears to be bipolar, has a variety of emotional kinds of problems like ODD, has ADHD, suicidal from time to time. The district concedes that the kid is eligible under at least something, and probably under most things with respect to the disability categories. But they're going to the wall on whether the kid actually is in need of special education. And they're doing it by saying, look, he's got successful academic performance. So this time, emphasizing this idea of academic performance as the content of what education in terms of the need for special education is. And that then gets joined and is the issue that winds up being presented, in this case, to the Ninth Circuit. The parents' attorneys seem to not want to take on in quite as direct a way as we've seen in some of the other cases, whether education or whether educational performance or whether need for special education is something that ought to be given this very broad definition to try to then encompass the kids' deficiencies or the kids' problems with school, but instead emphasize, and the court winds up then endorsing, the idea that, well, the kid is performing okay in school, but the reason the kid is performing okay in school is the variety of other interventions that the kid is getting beyond what the kid would normally receive in a regular education or what now might be called a general education classroom. And the services that they think are the things that effectively mean the kid is already getting special education, and that therefore that's what is showing that the kid is in need of special education, are specifically designed mental health services. So mental health services that actually relate to the kid's individual needs. Assistance, at least frequently enough, from a one-on-one aide, and occasional clinical interventions from the district behavior intervention specialist. And that, they say, is stuff that they don't think of as being part of general education. Instead, they are specialized services. And so to that extent, the kid is shown actually to be in need of special education simply because they're getting all of these services, even though they're not called special education. I hadn't seen that kind of argument developed in the case law previously. And so I thought that that case is one to watch to see whether it's adopted at all outside the Ninth Circuit, whether it might have legs that would enable it to be applied elsewhere. You might very well be critical of that view, saying that, well, no, the key thing is to keep kids out of special education by providing all of these additional services. And no, they're really more accommodations than they are special education. But the court would disagree on that and say, no, effectively what you've done is you've given special education without giving the kid the identification that would trigger the various procedural protections that would be applicable under IDEA. I wanted to mention beyond that, there is this preschool, elementary school, or secondary school education provision that's in the New York law, and really is quite seriously implied or actually included in the text of IDEA with regard to the definition of free appropriate public education, that it's something that doesn't go beyond secondary education. Now, it is true that in a number of cases involving things like compensatory ed, courts have approved post-secondary programs. They've also approved post-secondary programs as being part of what the kid needs for appropriate education in situations where a post-secondary education might be considered to be part of secondary ed. So for example, if, as is the case where I'm from, if the school district doesn't have a calculus course at a given school, but the kid wants calculus, the school district will essentially tuition the kid out, if the kid's in general ed, to get calculus from the local community college. Courts have said that, well, that means that in those situations, at least if the kid needs higher math and the kid is a special ed student, even though the kid isn't entitled to services beyond secondary education, that might still be a component of appropriate education for that kid. That being said, the courts have been adamant that still the basic requirement of what's the entitlement under IDEA is preschool, elementary, and secondary, rather than anything more than that. Anything more than that, what we're talking about would be the obligations of the community college or the university or the college to comply with Section 504 or comply with the ADA. And there have been some difficult cases in which the kid has accumulated all of the credits for graduation, but maybe for a good reason, the parents are not keen on seeing the kid graduate and seeing the services from the school district terminate. The TM against Kingston case looks to be that. It's a case from 2012 out of the Northern District of New York. Kid completes all of the requirements, even for a regent's diploma, but never actually manages to apply for and receive a diploma from the school district. Court says kid's not eligible anymore. If you've completed all of the requirements, even if you haven't filled out the paperwork to actually get yourself the diploma, you're no longer eligible under IDEA because you're not eligible for special education anymore. So that is probably worth keeping in mind as another issue that may arise, and at least a bit of precedent as to how to try to deal with that issue. Back to you, Deustadie, for a moment.
Okay, code number 4 is on the screen. Please write code.
Oh, go ahead, please.
Yeah, please write code number 4 on the affirmation form. We'll leave it up for 10 or 15 seconds, but code number 4 is on the screen.
What I wanted to ask Deustadie is whether we had any questions or comments that we wanted to maybe handle while the code is up on the screen.
No, we don't have any other than I got at least one hearing officer telling me that it looks like New York City DOE has closed schools for students, but the central and field offices are open. So there's a question for whether the hearing office is also open. Just that's the relevancy of that. That the hearing office may still be open, not sure, but the schools have been closed for tomorrow. So code number 4. So you may want to make some inquiries, folks, if you do have hearings scheduled for tomorrow. Would OPWDD, I just got a question. Would OPWDD services for, say, teenage girls' hygiene needs be analogous to parents providing a tutor? District will still need to provide such services on its own.
I'm not sure I can figure out
the question.
Yeah.
Neither can I. Would okay. Only as you, Nancy, would. Would OPWDD services for, say, teenage girls' hygiene needs be analogous to parents providing a tutor? District would still need to provide such services on its own. I'm not sure I can decipher that one for you, Mark.
Well,
sorry.
I guess what I would say that might be relevant, and I'm not sure, is that things like what could be either sex ed or health ed or something like that, would seem in general to fit neatly within category of either elementary or secondary education. If the services are being provided by a non-school district type provider, I suppose there could be some questions as to whether they would fall within education or not. And it could be that there would be problems with regulatory requirements, say, out of the the State Department of Education as to whether a school district, for example, would get reimbursement for an outside provider like the state mental health or the state rehab agency or the state health agency or something providing those services. I think it would still come back, though, to whether the kid might be entitled to that as part of the kid's IEP based on the child's educational needs, and that the services would have to be provided if that's one of the goals on the IEP.
Well, Mark, we can move on. You have
Okay.
about 10 minutes left, so.
Okay, I think we can probably cover what it is we need to do within that period of time. So the couple of things that I want to make sure that we talk a little bit more about are a bit about Section 504 and how that relates in, and a bit about statutes of limitations and how that applies. We've been kind of dancing around the Section 504 issue for quite a while here, and so to that extent, a little bit of this might repeat what it is we've talked about before. I did want to get across the point that I at least felt hadn't been maybe adequately appreciated in that relatively recent class action case that came out of the Second Circuit, the BC against Mount Vernon case. And I did want to emphasize that there is a regulation provided in not the IDEA regs, but rather in the Section 504 regs that says that all children who are eligible under IDEA do then necessarily qualify as being eligible under Section 504. And that's what our friends, the federal regulators, say. Whether that's relevant to your cases under IDEA, though, is more doubtful. It might be relevant, as in the BC case, to whether there's a valid claim under Section 504, but it doesn't really answer the more pertinent question, I think, to the hearing officers, which is, so the kid's getting services under Section 504, does that then mean the kid is eligible under IDEA? And the answer is, well, not in and of itself, plainly, because you still got to meet the IDEA definitions. And so that remains sort of as the short answer to that question. The longer answer, though, is a little more of a problem because you do have these various situations where kids do get services under Section 504, and you're kind of answering or trying to answer the counterfactual, well, yeah, but is the kid still in need of special education? Would the kid be in need of special education? Is there an adverse effect on educational performance for the fitting into the disability categories? Those kinds of questions that may be relevant. And so I thought that most pertinent to that topic would be cases like that LJ one, saying that services, even though they're not designated as special education services, effectively are special ed services. And so if the kid can't succeed without them, the kid is in need of special education and so fits under the IDEA definition. But also to note sort of the contrast between, on the one hand, Hood, that one Ninth Circuit case from 10 years ago, saying, yeah, kid's getting a bunch of Section 504 accommodations, is doing just great, and so therefore is not in need of special education. You know, and obviously there are other cases that follow that. In contrast to Mr. I out of the First Circuit saying, well, the kid's getting various accommodations under Section 504, but the fact is the kid is still in need of special education, although with Mr. I emphasizing more the idea that there are needs beyond what needs are being met by the Section 504 services. So you've really got a variety of precedent that you can kind of jump onto for almost any kind of conclusion you might reach there. But to my mind, the LJ approach has some persuasive impact. So I think it has some justification for being looked to. Let me mention statute of limitations, because it's a topic that comes up for quite frequently and seems in some ways to be of particular pertinence, especially when we're talking about child find related things, because with child find, the basic idea is that the school district didn't do anything. It's kind of an omission. And so you wonder, well, so when does a cause of action for an omission accrue? And kind of conversely from that, so then, and if it has accrued within the time for filing the due process hearing, then how far back can the remedy go? I put the couple of provisions that relate to limitations on the PowerPoint slide. The key case that's not a Second Circuit case, it's a Third Circuit case, but the one that certainly has gotten all of the attention, all of the ink, and has been followed now in a couple of other jurisdictions, notably District of Columbia, is GL against Ligonier, or as I would say it, or Ligonier, as I guess the folks who are from that area say, Valley School District, which essentially says the limitations, the 2 years limitation in IDEA is just like any other old statute of limitations, to the extent that if you get the action on file within the period after the date of accrual, that you can get a remedy going back to the beginning of time. The real question is whether you've gotten the action in within the limitations period from the date of accrual. So it's not much different than if they left a sponge in my body after surgery 14 years ago, but I don't have any reason to suspect that until a year ago. I've then got a 2-year medical malpractice statute of limitations. I file now, I can get damages going back to the event from 14 years ago. The court, once you apply that approach, you then have to ask, so then what does this do with this omission for child find? The DeMarcus case, which does apply GL, seems to give you at least a possible answer to that, saying, well, the accrual date is when the parent reasonably should have suspected something was wrong, and you have to look at that based on really the education or lay level of the parent. So here you've got a parent who is a layperson, doesn't have any educational expertise, and the court says that accrual there is when the alleged violation of child find should have been immediately apparent to even a layperson like DeMarcus's mother. Although my recollection is that they actually then remanded it back to the hearing officer to try to figure out exactly what that is. I've got the other case, that KH case from New York, which is actually before any application of GL, but once again talks about this idea of whether the parent should have known of the deficiency in services such that should have known that the school district was neglecting its child find responsibilities. And so for that reason, the statute of limitations is met or is not met. And I've got Somoza as another case that sort of fits along the same lines. The DK against Abington case is the one that sort of stands out a little bit in the other direction, where the court really seems to want to go back and give a remedy only for the couple of years preceding the date of the filing of the action. That was actually limited but not overruled in GL. So there's a question whether it's even fully applicable in the Third Circuit, but the fact that it's overruled by GL, or at least limited by GL, doesn't mean that it couldn't have persuasive effect outside of the Third Circuit. So it does at least provide one other alternate approach that might be a somewhat more restrictive one with regard to the application of statute of limitations. To my mind, though, it isn't really a problem with limitations. It's really a problem with accrual. And when it is you think that the parent reasonably should have known of the problem that the school district didn't deal with, that is the basis for the child fine violation. So I hope that's kind of adequately or as clear as we can do. I know we're running kind of low on time. Maybe I'll turn it back to Deostady, Lynn, and Michael to see whether there are parting comments.
Can you turn to the last slide?
Oh, I should.
Code number 5 is on the screen, folks. Code number 5 is on the screen. Please write it down on the affirmation form. Code number 5. Michael, Lynn, any final thoughts?
None here.
I have one final thought. There's a lot of emphasis on grades in the case law in terms of determining whether a student is eligible or not. I think it's important to note that the reality of education in America can be that some students are given good grades even though they're doing terribly in school. And if there's any suspicion of grades that are more or less meaningless, the hearing officer should look into it.
I think that's reinforced by that Compton case, among others.
Good. Thank you, Michael. Thank you for your participation, and Mark, thank you for your
Yeah.
presentation this evening,
Thank
and
you
Lynn
all.
for your assistance. Folks, it's 8 o'clock and we finish on time. Code number 5 is still on the screen. I'd like to remind you that the third and final webinar for the season is scheduled for May 15th. So the final and third webinar is scheduled for May 15th, Tuesday, May 15th. So look out for the registration email, which will go out a week to 2 weeks before the webinar. Thank you for your patience tonight. I hope everyone's safe tomorrow, and we will be speaking soon. Have a good night.
Okay, thank you all.
Thank you.
Dave Steady,
Yes.
could you give Mark and I a call?
At the end. Yeah. Thank you.
Okay.